The number one reason why an annulment is not better than a divorce. Port and Sava, attorneys at law. There is a lot of misunderstanding about what an annulment or marriage annulment is, and when it should be used. It is a legal holdover from a time when no-fault divorce was not available in New York. Equitable distribution and maintenance, alimony, are still available to be awarded in an action for annulment. Let's start by describing exactly what an annulment is. It is a legal procedure that renders a marriage null and void. An action for annulment does not get rid of maintenance, equitable distribution, or issues of child custody and child support. New York law provides several grounds to annul a marriage, if one or both parties were under 18 at the time of marriage. However, this ground is waived if the parties continue to live together after turning 18, answering the question of how long can you be married and still get an annulment. A marriage can be annulled if one or both spouses lack the mental capacity to consent to the marriage. If either spouse is physically incapable of consummating the marriage, and this was unknown at the time of marriage, this request must be made within the first 5 years of marriage. A marriage can be nullified if consent is obtained through force, duress, or fraud, or in cases of bigamy. Examples of fraudulent practices include marrying for immigration status or lying about the desire to have children. If a spouse has been mentally ill for over 5 years and the illness is incurable, an annulment can be sought. Annulling a marriage in New York requires a trial. New York is a no-fault divorce state, and the judge must always grant the divorce. The person filing must prove at least one of the grounds in court. A judge does not have to annul the marriage. The process starts by filing an action in the Supreme Court. At the first conference, called the preliminary conference, the court will set dates to exchange discovery. In addition to providing documents relating to the annulment, the court will also want disclosure on financial records to include tax returns, bank records, pay stubs, business records, retirement accounts, etc. The next step involves gathering evidence to support your grounds. Discovery can be very expensive as you will have to pay your lawyer to conduct it. Finally, a hearing before a judge is mandatory. The judge will review the evidence and decide whether an annulment should be granted. The trial will be expensive. An annulled marriage is considered void, as if it never happened. However, this does not affect the legitimacy of children born during the marriage. Additionally, the court can make orders for custody, visitation, and financial support of minor children. Also, the court can distribute marital property fairly between the former spouses. That means even if an annulment is granted, you may still have to divide houses and bank accounts acquired during marriage. While the annulment process may seem like a clean way to end a marriage, it's not always the best option. Proving the grounds for an annulled marriage can be complex and requires a trial, making it a lengthy and potentially expensive process. In contrast, a no-fault divorce allows spouses to dissolve their marriage without assigning blame. The recurring myths. There are 2 recurring myths about annulment. One is that the winning spouse will be vindicated. While I realize that a person may be hurt as a deception was practiced, under the law there is no vindication. The second is that with an annulment there is no equitable distribution, post-divorce maintenance, or other orders. This, as I have pointed out many times, is utterly false. When is an annulment a necessity? There are times when a third party will intervene. One example is when underage children marry. The second and more common situation is the mentally incapacitated person who gets married. While it may appear that an annulment can provide a fresh start, it's not always the easiest or most practical solution. Call Port and Sava 516-352-29999 for a free 15-minute consultation.